Thank you for joining us. We're a much better organization because we work well with the insurance department. And in San Francisco, we were able to have several individuals from the insurance department attend. Carol Frere from the legal division, Bob Liu, with whom you all work, the head of financial analysis. Emma Hirschhorn was there, because of legal. So we had a nice cross-section of individuals who joined us in San Francisco. I'd like to spend just a few minutes, it's about 15, 20 minutes, going over with you the significant legal events that occurred this past year and what we foresee in the upcoming year. And regularly, we will try to present an update of this at our annual meetings. And also, you may have seen in our monthly bulletins or periodic bulletins, we now have a legal section in the bulletins to keep you advised of the legal positions, the issues that are confronting the association, and the positions that the association are taking. So with all that, we think you'll be better informed. And we invite your feedback on these issues as well. If there are certain issues you think that we should become involved in or you want to know more about, we're happy to help you with those. This is a brief overview of the types of things that we're going to be briefly touching upon today for 06 and 07, various litigation, legislative, contingent commission, appropriation fees, etc., and then some updates, including the new administration that we have under Commissioner Poizner. We have an export list hearing, as we typically do every 6 months to a year. And at this hearing, the Surplus Line Association presented testimony. Hank Alderman was instrumental in that testimony. One of the key things that Hank wanted to touch upon was extension of coverage, short-term extension endorsements. This is something that apparently has been plaguing the industry for some time, where one of your endorsements, one of your coverages might be about to lapse. You don't have time for a variety of reasons to replace the coverage for a full term. You need a short-term endorsement. And the question is, do you have to actually physically do a new diligent search? Is it, in effect, a new coverage for which a diligent search has to be performed or not? And in the past, the Department of Insurance has taken the view that, yes, you had to. Well, as any of you who have been confronted with this know, it's extremely difficult on a short-term endorsement to do a diligent search. In fact, nobody's going to take the coverage, so it almost seems like a ridiculous activity to have to perform. So as a result of that, there was a proposal made and presented by Hank for an extension of coverage for a period not more than 90 days, provided by a surplus lines carrier on the same risks insured under an existing surplus line policy. Such an extension may not include a change in coverage, terms and conditions, or limits, and additional premium, if any, is determined pro rata based on premium of the existing surplus line policy. We are hopeful that this will be approved by the insurance department. We think that it will be, and so you'll be all better off for it. We did have the cooperation of the Association of California Insurance Companies. There was some testimony by them in support of this as well. And we've been through Kerry Sullivan and other sources. We've been liaising with the new end markets to make sure that we don't run afoul with their concerns. Here are a couple of the other export list hearing coverages that were considered. We should have a decision by the end of this month, I believe, which is next week. So keep our fingers crossed. We also, after quite a while, quite a bit of litigation, and our involvement as amicus in the Crusader Insurance Company versus Harry Norris case, it finally came to a finality through a Supreme Court decision declining to review the Court of Appeals decision. This case dealt fundamentally with issues of diligent search and exploitability of risks. So we're now finished with that piece of litigation. There's another piece of litigation, however, that we're quite interested in. It's one that I mentioned to you last year at this time. This is the so-called B2B case, where we have an unusual situation with a retailer or wholesaler and then an overseas Indian software developer that failed to perform. and the wholesaler is being exposed to some potential liability that the wholesaler never had any contact, any credit for, I should say. The Court of Appeals held that the wholesale insurance broker may owe a duty of care to third parties that are not the broker's client, not insured under the policy procured by the wholesaler, and with whom the broker had no direct contact. This is something that concerns us greatly because we think this could be expanded to other situations, and if you are operating in a wholesale capacity, it could expose you to risk of loss, even though you're not in privy to contract with the original insured and retailer. So the association is watching this very closely. We're assisting trial counsel to make sure that they understand the surplus line types of issues. We also, on the legislative front, early in the year, had thought it wise to sponsor Bill AB 2840 to eliminate broker violations for unintentional non-admitted placements. And you'll see the exact language there that we have proposed, striking actually from knowingly placed with a non-admitted insurer. The insurance department didn't like that. The Association of Insurance Companies didn't like that. And so the association thought the better part of valor was to withdraw this proposal, and we so did. On the contingent commission front, there have been several developments. This all started nearly 3 years ago in March of 05. And we've gone through a lot of changes consistent with Joy's representations today, including the fact that Attorney General Spitzer is now the governor of the state of New York, so presumably he'll be a little bit less active in this area. But we have Andrew Cuomo, who is taking over, keeping active. We have Attorney General Blumenthal in New York, or in Connecticut, who's continuing to be active. So we must be vigilant with respect to these contingent commission issues. The most recent case is the state of Connecticut versus Accordia. Accordia has taken a very strong view of this, and I believe that there's going to be some litigation involving this, which in a sense could be good, particularly if you're not in the crosshairs for the litigation. And it could set down some standards. So we'll keep an eye on that. Chubb, in the meantime, has agreed to discontinue contingent commissions entirely. Travelers, St. Paul Travelers has done likewise. And if you notice on the second one, we have a situation where a number of the large insurers had prior agreed with Attorney General Spitzer that if any particular line that they write, they find that as a market there are not contingent commissions being charged, then in 65% of the market, then they won't as well. And the 65% tipping point has been reached now with auto, homeowners, and several other kinds of insurance. And accordingly, these insurers that have prior agreed with the Attorney General in connection with their settlement, AIG, ACE, and Zurich, as well as St. Paul, will no longer contingent commissions in those lines. There has been a little bit of regression on the contingent commission front as well. That is where the Attorney General has decided that when there is a special relationship demonstrated by a producer acting as a managing general agent, that the managing general agent is so close to the insurance company, and everyone in the public is well aware of that, that there is no need for there not to be a contingent commission. In other words, there's no steering of business because the business that comes to the MGA effectively comes to the insurance company. So there is not due to be a conflict of interest. Accordingly, if you're in an MGA relationship, it sounds like you can charge contingent commissions or enjoy the benefits therefrom. Switching gears slightly from the contingent commissions to the broker and agent fee front, we have, this is somewhat new, and the issue here is in what instances may a producer charge a fee in addition to a commission. The insurance department has taken a fairly rigid view to say that if you are acting as an agent, you are not entitled to charge fees unless your principal, the insurance company, has authorized it And secondly, your principal, the insurance company, has filed rates with the state of California stating that those fees are part of their rates. Now, that all sounds kind of nice and legalistic, but in practice, it's awkward. For example, if you have multiple offices, or if you have different layers of placement, you may find different individuals in your office performing functions that are not always agency-type functions. They actually may be brokerage-type functions. However, the Department of Insurance, if you look at the second sub-bullet under the second bullet, action notices appointing broker as agent makes broker an agent for all purposes. If an action notice has been filed by the insurance company indicating that you and your organization are an agent, for all acts that you do, you are viewed as those are viewed to be agency acts. And as a result, you cannot charge extra fees. Well, what do you do when you have an instance where you're doing an environmental study as a producer? There has to be a $50,000 fee charge for the environmental study, and you want to pass that charge on to the insured. I mean, rightfully so. It shouldn't come out of your pocket. You can't do it under this principle unless your principal, the insurance company, has prior authorized that and has made it a part of its rate file. That, to us, is ridiculous. Likewise, you shouldn't be able to charge fees for typical agency-type acts, such as issuing a policy when you're an agent. I mean, that's supposed to be part of the commission. So we have two extremes. Whenever you have two extremes, we have to find a middle ground. So we're working with the insurance department now, and frankly, we may have to seek some legislation, or there may have to be some litigation or some such thing. But we don't think that every act that you perform as an agent, or every act that's performed because there's an appointment of an action notice appointing you as an agent, necessarily precludes you from charging fees in appropriate cases. And we're trying to find some common ground on that. There is one case, there have been a couple of settlements in this area, one of which is American Reliable. The American Reliable case now has gone before the OIL in a special way. That is, the insurance department wants to say, because there was that settlement should be deemed to be precedential in nature and should apply to the entire industry. We filed an amicus letter with the OIL saying to the contrary. IBA West has also challenged it. We're hopeful that the OIL will reject the precedential nature of that holding so that whatever happened in the American Reliable case doesn't otherwise apply to you. There have been some other regulatory developments, some of which were discussed by Ted. We got the NAIC Reinsurance Task Force alien collateralization. This is where we're dealing with whether or not one size fits all in connection with collateral that needs to be established for reinsurance credit. And fundamentally, it's the dialogue between European and American insurers with the RIA. That's been going on for years. We're starting to see a bit of a breakthrough on that. Jerry Sullivan and Hank Altman have been involved in taking a look at that. It doesn't directly impact the surplus line brokers, but it's a peripheral development. Then we have a form now, the NAIC Surplus Line Task Force dealing with multi-state surplus line tax allocation. This has been a problem since the 60s, where when you have multi-state risks, how do you determine where you're supposed to file your taxes? Safeway stores, for example, throughout the United States, how much goes to California, how much goes to other places. And the burden to date has been fundamentally upon the broker in order to make those allocations. We'd like to shift that burden and say, hey, all you have to do is pay once to pay the right amount of the tax to somebody, let them provide the rest. So we're working carefully with various standing offices and the NAIC to try to develop some rules to that effect. Ted Pierce has been heavily involved in this, and I think it will benefit members well if we get some healthy resolution there. We also have had our first California Surplus Line Advisory Committee meeting. That was held in the fall. This was with the insurance department. These are the items that we covered. E-filing protocols. We were also reviewing the Leslie and whether or not it's easy enough to get on Leslie and easy enough to take inappropriate companies off of Leslie, and we're trying to facilitate the both getting on and off of Leslie in that regard. We're also taking a look at drafting some SLA bulletins regarding independent procurements and courtesy filings. We understand that a number of offshore brokers have been providing incorrect advice that a surplus line broker can avoid surplus line laws by labeling placement as independent or direct procurement under Section 1760 and be compensated as a consultant, thereby circumventing the surplus line law. You're just telling the client the risk that you just call yourself an independent procurement, which means constitutionally you have the right to go outside the state and negotiate your own insurance. We'll only act as a consultant, therefore we avoid surplus line tax and filings. We think that's inappropriate when done by a licensed surplus line broker, and the department tends to agree with that. And we may be receiving bulletins to that effect. Courtesy filings, now that we have non-resident broker, surplus line broker licenses that are available, there's no need for out-of-staters to come to you to make a courtesy filing for forms or for taxes on their behalf. But remember, if you do so, you accept some obligation, and you could accept some liability if, in fact, there's a claim that's not paid or something else that does occur down the line. So we try to discourage that, particularly when there is surplus line, non-resident surplus line license available for others to utilize, and then they can make their own filings. On the export list, as I've indicated, we expect a decision by the end of this month. We're going to work with the ACIC to clarify some definitions on the export list. They've reached out to us. We've said we'd be happy to cooperate. Litigation-wise, we're going to continue to monitor P2P, any other significant cases that develop. We may have to pursue, as I've indicated, some legislation to resolve the agent broker fee issues. We also might have to ask the clarifying amendments regarding 1765. That's the Leslie applications. What kind of data we're working with the department on that. We're going to monitor the NRRA. Ted previously referenced that. This is a subset of the so-called SMART Act. The SMART Act had 17 chapters. This was one of those chapters. And that got through the House, but didn't get by the Senate. We're going to continue to monitor the development of that contractor business. With respect to regulatory, we have the new California reinsurance regs that became effective January 1st of this year. They're substantially similar to the NAIC model for credit reinsurance regulations. They added a new concept of volume insurer, which is the equivalent of a commercially domiciled insurer, which under the Holding Company Act, which is kind of technical, but says for 3 years if you've done 30% of your business in this state, you're deemed to be commercially domiciled, if you live otherwise domiciled elsewhere. Well, essentially, these volume insurers a volume insurer under the definition of a substantial volume of business in the state to be in effect a domiciled California company, and therefore certain bells and whistles apply in terms of sessions of reinsurance. And regulates reinsurance intermediaries. If any of you are a reinsurance intermediary, you've got to read those regs carefully because you are now regulated and you are subject to examination. We also will pursue the e-filings with the department and the Leslie standards and any other surplus line issues with the advisory committee. With respect to the new administration, you all know that we have a new insurance commissioner effective January 8th, Steve Poizner. He comes from a Silicon Valley background. Most of you probably are aware of that. He has an electrical engineering degree out of Stanford University of Masters. He also started a company called SnapTrack, developed a little GPS chip in your cell phone, which helps to track people and such. Sold that to Qualcomm for $1 billion. So he did not need to take money from the insurance industry. He's independently wealthy and wants to make sure that he doesn't take money from the insurance industry, so he won't be viewed as being compromised. He is going to hold over Rick Vaughn and Gary Cullen as chief deputy and also as general counsel of the department for a short transition time. Also, as an outreach towards bipartisanship, one of his principal goals is to run it by the nonpartisan administration. Eventually, Jim Richardson, who came from Assemblyman Rolte staff, will join him probably as chief deputy, and is involved in this transition staff now. He also wants to focus on insurance fraud, competitive rates, bringing technology to enhance the insurance department, and probably insurance efficiency, and disaster preparedness. He's very keen on earthquakes here in California, and like the low penetration rate of individuals obtaining earthquake coverage, and what's going to happen when the big one hits, whether it be in northern Southern California or the entire state. So that's, I think, it. Anybody has a question, I'm happy to answer it. Or we can take a break and I'll be around and answer down there. Yeah, oh, I'm sorry. Yeah, I should have said that at the outset because I know everyone was madly taking notes. This will be on the website of the SLA, so you can just pull it off. And if you read it at your leisure, if you have questions, always feel free to email me or the association. We'll be answering for you. Okay. Yes,
sorry, Jim, I had one question. You said that on the contingent commissions, you said that the Marsh and Aon settlements have been amended so that perhaps an MGA type activity would be exempted.
Right.
But you also said that AIG, Zurich, and others, having reached the 65% threshold, can no longer provide contingent commissions on certain lines.
Right. Well, they act as a broker.
Does the second, does the change in the Aon settlement also pertain to that? So that AIG and Zurich may be able to...
Yeah, that's an interesting point. I have to reread that. I would think it should, because they're in effect an insurance company. So I don't think that 50.65% would apply to those instances. And if they did, it's for drastically. I mean, logically should apply. If you're an MGA, you're the equivalent of the insurer, there is no acquisition or steering, you should be able to obtain overrides or contingent commissions and the like. And if you're acting in a brokerage capacity, then that's where the conflict of interest presumably arises, or as an independent agent. That's where the conflict purportedly arises. So thanks for the subtle but meaningful question.
Yeah. On that same note, can you use the words from MGA are using as defined in the insurance code, or are you using it loosely?
Yeah, that's another good question. I'm not using it in any context. The reason I say is the following. These were New York decisions, so they wouldn't naturally be defined by California law. But again, I would be guided by logic in this instance. If you qualify as an MGA under California law, that should be sufficient, even though that was a New York deal, and I think you're going to be safe. So that would be the purest form. If you deviate somewhat from that, you still may enjoy some comfort of being viewed as tantamount to an MGA, but the more you drift from a statutory definition, the more risk you inherit. Does that help you?
Yes.
Okay. Yeah, I mean, this is all tricky stuff, and we're kind of finding our way along. I always like to reemphasize these things. Disclosure is so important. It's the antiseptic to a lot of this stuff. So if you are disclosing, I've encouraged a lot of our clients to enter into engagement letters with their clients, and just put in there, look, we receive fees from this, fees from that, fees from the others. And as a result of that, if you carefully disclose what the tripwires are in a generic sense, not the whole mathematical formula that must ask, you have disclosed to the insured then can make an informed choice as to whether or not to do business with you. And if they choose to do business with you, great. And I would think in most instances, they will choose to do business with you. But disclosure is very important. So that can cure an awful lot of stuff. And I really encourage you to put in writing what your relationship with your insurer is, or the retailer, if you're a wholesaler, is, and spell out the basic overrides and things. You're entitled to earn money, so don't be afraid of that. This is America. It's kind of the way the whole system works. Any other questions? Yes.
25 years ago, we kind of created a system called single policy where you have multiple insurers all over the country. I soon learned that it's not the United States, it's the divided states. And kind of figure that every state has its own regulations, and it was very difficult when you had practices located in states at a single insurer or under the master policy. So we did do that. 25 years ago we were doing that. We never got clear clarification from any insurance department of the ability legally to, is it correct where to take the standard fee? Is it in the domicile of the main insurer, or is it the homeowner in this particular case which is the additional insurer of the policy? There's been no legislation anywhere in 50 states, so all the investigation we did, we found that it can be done under the basis of a single master policy, and paying the tax and fees to where the domicile of the residents of where the home office comes in. And that has not been challenged in probably 48 states. Now I'm curious, you're saying that under new possible legislation, multiple states can be brought in under a single document. And
there are two issues here. One is where did the transaction occur, and the other is where are the properties located. The transaction is governed by regulatory law, and your license is subject to where the transaction occurred. Typically, that's in one state. Not almost all of that, but typically it's in one state. You enter into agreements, negotiations in a particular state to cover a variety of properties. The properties lie outside in a variety of states. They're the subject of the taxation. Every state wants its pound of flesh and to divide the insurance premium in some manner that gives fair proportion to the location of the risk in their particular state. The surplus line broker today has been challenged to try to figure out what formula that is. And we're trying through this special subcommittee now to come to grips with you possibly paying to one national clearinghouse the amount of the tax that would be assessed, and let them divide it up amongst the various states so that you're not caught in the crosshair. There's not been a lot of litigation in this area, but it's always been a burdensome mechanism, one that burdens the broker more than the regulators. So we're trying to work with them on that. I don't know that exactly answers your question, but hopefully it gives it a little more context.
I'm just curious to see if there's any headway been made in this difficult.
Yeah.
I mean, because
I think so.
Wants their own, everybody wants their taxes, every state wants their fees.
Yeah, and we want to pay 100% of the taxes. This is not an effort to avoid or evade taxes. We know it costs $100. Or whatever the number is. Here's the $100. You guys go spend hours now to be Jim Pettipass is anxious. He's pulling the plug on me. So if there are any other questions, I'll be happy to